Yes. Thank you very much, Mr. Anderson, or whoever it was who arranged for the version 7.
My sister,
Well, thank you very much for doing that.
so we've hopefully got copies of it as well on your.
We have.
As well as copies of Part 9 of the immigration rules as they stood for the time, which I thought you might be happy to have, because that's where the amendment related to Rule 9.41 is relevant. So what I was proposing to do, my lord, was just quickly to take a look at version 7 and Part 9, and then return briefly to the judgment. And then, in a sense, my submissions on ground 1 have, to a large extent, been articulated already in the course of the exchanges that we've had, because ultimately it comes down to the interpretation of these passages of the policy.
Yes.
So,
It does.
looking then at version 7, what I thought might be helpful is just to get a sort of flavour of where that's similar to and different from version 11 of the policy. The introductory passages are largely to the same effect. They're not always entirely the same language with entirely the same structure, but they're to a similar effect. On internal page 7 of version 7, you have the section on relevant legislation, which again makes reference to Part 9 of the immigration rules, provides that must be consulted and applied before discretionary leave is granted. The section on reasons for granting discretionary leave is similar but more extensive in the new policy, but I don't think that particularly concerns us. And then the section on exclusion and criminality,
Yes.
which appears as section 3.6 on page 11, is also largely in the same terms as under version version 11. Just off my reference. Then I took you to a section concerning further leave applications, general grounds for refusal, criminality in version 11. There's no equivalent of that section in version 7. There's a section on several of those applications at page 22, which is almost identical to version 11. And then the transitional arrangements themselves at page 24
Yes.
are pretty much identical to version 11, and you'll see
The third paragraph is there.
section 10.1, the third paragraph is there. It wasn't quoted, but it is there. So that's what the external difference between those two versions of policy. What I've also handed up is Part 9 of the immigration rules, the general grounds for refusal. And it's paragraph 322.
So before you go there, just looked again. In 10.1, paragraph 2, there's a reference to criminality thresholds. And you told us, haven't you, that Part 9, the bits about criminality threshold things, wasn't in existence at this stage.
Rule 9.4.1 wasn't in existence, my lord.
Right.
Part 9 was in existence.
Yeah, but not the bit
Not
about crime.
9.4.1.
So when it refers to criminality threshold there, it can't have been referring to 9.1.4, can it?
It can't have been referred to 9.4.1 itself, my lord. No, I think that's what it is.
What is it referring to?
Well, it's not, my lord, again, a defined term. It may, though, be referring to the criminality thresholds that existed under Part 9 as was. And this is what I just wanted to take you to,
Yes.
which is paragraph 322, at page 291,
Yes.
Of the shorter document I handed up, under the heading refusal of leave to remain, variation of leave to enter or remain on terms of leave. In addition to grounds for refusal of extension to stay, set out in parts 2 to 8 of these rules, the following provisions apply in relation to refusal of application for leave to remain, variation of leave to remain, etc. And then you'll see that at 1C, there's a reference where a person seeking indefinite leave to enter or remain to various different thresholds for criminality that have, as it were, depending upon the seriousness as reflected in the duration of the sentence, different periods within which the sentence remains relevant.
Right. So those are the custody thresholds. Those are criminality thresholds then.
Well, these again are thresholds as to criminality. So in terms of the possible thresholds that it could be referring to, would in a sense be these ones, or it could potentially be referring to the thresholds in place under the old policy. But as I submitted earlier, that when you read those two paragraphs together is more difficult to see given the reference to the exclusion of criminality.
Yeah. It looks as if it's something different, and the only other thing it could have referred to was this, and it must just have been a carryover from what was there before. But he doesn't fall into this because it was the 7. It's not 4 years; it's 30 months.
15 years then.
Yes. Well, yes. The individual.
15 years needed to have passed, so he wouldn't meet.
So it's the end of the sentence.
And 19 years since the end of the sentence. Did that apply or not? Just on the facts, I just don't know.
Yeah, so on the facts, the offending itself was on 20th of April, it was 23rd of June 2006 that he was sentenced. So that would be more than 15 years.
Yeah.
It's astonishing, this phrase, criminality thresholds.
Oh, sorry, the relevant period is a period of 15 years since the end of the
End of the sentence.
Oh, sorry, yes.
So, he was. So when did the sentence end?
It was a sentence of
30 months.
30 months.
30 months. Was
Is
he
it-
remanded in custody?
What
or-
counts as the end of the sentence? The period of imprisonment or the period of the sentence?
Period of sentence.
Sentence. It's
So it's so it
So 30 months from the 23rd of June. What was the date again?
2005, but I don't know where I've got that.
Yes, it's 2006 that he pleads guilty. Let me see if I can identify.
Sorry, if I can assist. Obviously, this version the version which was applicable in Ellis. It's not the version which was applicable.
We
know,
know that,
we know
but we're
that.
treating it as a possible help to interpreting criminal threshold. If it was there then and that's been carried over, it's possible that the Secretary of State may even have given a mind to it,
Yes, I
or just
apologise.
carried it over by accident. So that's why we're worried about it.
There's no definition of criminality thresholds, and it is
I think that was
odd, isn't it?
that is perhaps what's changed though, because what 4.4.1 of the immigration rules has done effectively is introduce a single uniform threshold for the purposes of the immigration rules in relation to criminality. That's what Rule 9.4.1 itself does. So it might be considered in a sense to be an ambulatory provision where as the thresholds change over time, the reference is still the same, it's still the criminality thresholds, but those thresholds have changed by virtue of the introduction of Rule 9.4.1.
I'm still checking the 15 years. It is more than 15 years, I think, from the end of the sentence, because even if you got 30 months on to the 23rd of June 2006. You know, where we got an application got to be checked.
I was going to see if we can get confirmation in respect of that. But the submission that I make essentially is that the reference in the policies to criminality thresholds, when read in conjunction with the reference to the exclusion of criminality section, and to the fact that the relevant legislation refers to Part 9 of the immigration rules, must mean that it's the thresholds in Part 9 of the immigration rules. One of the things that's changed between version 7 and version 11 is that those thresholds have changed, because at the time of when version 7 was introduced, it's the thresholds that I've just handed up. Now it's a single uniform threshold provided for in Rule 9.4.1.
Yes.
And so that's why the Secretary of State's decision refers to that single threshold of the conviction with the sentence of 12 months or more.
Back to the question of assuming she wanted to apply that, not the
Yes.
pre-existing.
Of course.
Threshold singular then. It's one threshold now, is
It's
there?
now one threshold,
Even though the plural is still used in the
whereas
paragraph.
before it was a range of thresholds, yes. In other words, that was what I wanted to say in relation to those two documents.
And did you want to go back to Ellis, or have you finished with Ellis?
No, I don't think so. I think
No?
I've taken sort of points within that, and I don't think that looking at version 7 takes what I want to say about that.
No.
And in a sense, my lord, so far as the judgment itself is concerned and ground one of the appeal is concerned, effectively my submission is that the judge misinterpreted the policy by holding that in effect it requires there to be either new offending or, to use an illustration that she gave, new information about old offending. And in my submission that adds a gloss to the policy it isn't there. So if we can just turn up the judgment in the core bundle. I've taken you briefly to the point I was making about the order of the 1st of July 2025 on paragraph 44. And then when we consider the application to the facts in respect of historic offending, you've got my submissions in relation to the interpretation of the policy at a textual
Yes.
level, and so I don't propose to repeat those. And then I'd simply note that in relation to paragraph 49, the judge makes various points which in her view supported her interpretation that historic offending couldn't count. The first of those is that the judge says in the first sentence of paragraph 49, the fact that the claimant was repeatedly granted standard 3-year discretionary leave demonstrates the defendant accepted the conviction did not disqualify him from the 6-year pathway. I propose to note in my submission that goes too far because of the distinction between discretionary limited leave and settlement, which is always a privilege. And so the fact that the Secretary of State concluded that it's appropriate to grant a further period of limited leave, notwithstanding criminality, does not mean in my submission that the Secretary of State has decided or is obliged to decide that it would be appropriate to grant indefinite leave, notwithstanding criminality. Secondly, the judge suggests that reliance on historical criminality introduces uncertainty and arbitrariness into the scheme. In my submission, it doesn't. It certainly adds another potential factor that goes into an evaluation of whether settlement should be granted. But it's far from unusual that decisions in the context of the discretionary aspects of immigration law, so not like things like the points-based scheme, will include evaluation of a range of different factors. And then the judge returns to the statement that a lawful departure from the norm requires something new. And in my submission, again, that's a gloss on the policy. The policy could have said that, but doesn't say that. In my submission, Mr. Justice Chamberlain was right to recognise in Ellis that the various words normally were intended to confer a significant area of discretion on the Secretary of State. And it's consistent with the exercise of that discretion that the Secretary of State may consider that, notwithstanding the old policy says you'll normally be entitled to a grant of indefinite leave after 6 years or 10 years, that shouldn't be applied on the basis of the current criminality thresholds. And those are essentially my submissions in relation to ground one so far as the discretionary policy is concerned. So far as the medical leave policy is concerned, it's effectively to the same effect as I submitted earlier in my submission. The medical leave policy doesn't materially add in this context, and the Secretary of State was entitled to consider that the criminality was a compelling reason not to grant indefinite leave to remain. And those are essentially my submissions in relation to ground
Thank you.
one. In relation to ground two, if we can then turn further in the judgment to page 106 in the core bundle, under the heading conclusion and remedy, paragraph 61, the judge summarises her conclusion that the policy mandated a grant of indefinite leave to remain unless there was a lawful new basis to depart from the norm. And then at paragraph 64 says, given the court's conclusions and the proper construction of relevant policies, the only lawful course is to grant indefinite leave to remain. Remittal would serve no legitimate purpose and would cause further delay. The court exercises its power under section 31 of the Civil Courts Act 1981 to grant such relief as is just, where the policy framework gives no lawful basis to refuse or the outcome is inevitable, substitution rather than remittal is appropriate. So in terms of the way that the judge's decision is expressed, it's expressed as being that substitution rather than remittal is appropriate. Now, if I can then ask you just to turn up the order of the learned judge at 92 of the core bundle. You'll see that paragraphs 2 and 3 aren't as such expressed in terms of a mandatory order or a substitution. They're expressed in terms of paragraph 2 of the decision being quashed and in paragraph 3 of a declaration that the decision is unlawful because on the material now before the defendant, the only lawful decision is a decision to grant indefinite leave to remain. So in effect, in my submission, that was plainly intended to achieve and in fact would achieve what the judge had outlined in her conclusion on remedy, that is to say, a de facto substitution of judgment, even though it's not quite expressed in those terms in the order, and I'm conscious it's the order itself, it is as it were the subject of the...
But it's paragraph 4 as well.
Yeah.
Shall should implement a new decision, and the only decision, unless something happens within the next 21 days, is the grant of ILR.
Yes. And in my respectful submission, my lord, in that, the judge went too far and effectively reserved the function assigned to the Secretary of State. In relation to that ground, just turning to the authorities bundle, the decision of the Supreme Court in, forgive me, here's my note, in IMA, you've got tab 11, page 194, paragraph 44, which is the sidelines paragraph, noting different remedies of different degrees of impact and capacity for public authority to carry out its functions, portion of the usual range of public law which obliges the authority to retake decision in a lawful way. Such an order allows the authority to exercise its own judgment in retaking a decision that regard to all relevant interests. Acted, whereas a mandatory order takes a matter out of the hands of the authority to that extent, makes the court the primary actor. Accordingly, when deciding in the exercise of its discretion to grant a mandatory order to require authority to do a particular thing, the court has to have regard for the way in which an order of that character might undermine to an unjustified degree the ability of the authority to fulfill functions conferred in it by Parliament. Then, my Lord, I'm very grateful for the composition of the court drew our attention as well to the authority of LND 1, which I don't know if yours have copies. Again, I've got copies I
I
can hand out.
remember it, but I suspect my colleagues will not.
I'll just hand these up then if I may.
I think I've got a copy, let me just check. I thought I had. Seem to have mislaid it, so.
And it's paragraphs 59 to 62.
The judge had done the same thing. He said, I don't like the way the policy is being interpreted. I would grant the application sought effectively. Not immigration. Well, it was immigration, but it was Afghan judges coming here.
Yes. And paragraph 59 summarises the relevant principles of the report. Paragraph 60 notes, as Roger was just summarised effectively that. Decision. And the ultimate conclusion was that the order to vary to provide the matter of quashed. Now, of course, any remitted decision will have to be taken lawfully and taken lawfully in regard to considering the contents of the judgment of the court on the basis of which the court is taking the action as it's taken. But in my submission, that would have been the appropriate course of action would simply have been to quash the decision and then leave it for the Secretary of State to remake it. That's also, in my submission, supported by the Senior Courts Act 1981, Section 31, which you've got the authority bundle at tab 2. And on page 11, section 31(5), if on an application for judicial review, the High Court makes a quashing order with respect to the decision the application made, it may, in addition, A, remit the court tribunal authority who made the decision with the directors to consider the matter and reach a decision according to the findings of the High Court, or B, substitute its own decision for the decision in question. 5A, that latter power is exercisable only if the conditions that the set out therein are satisfied, decision being one made by court or tribunal, quashing being grounded within an error of law, and without that error there would be only one decision the court or tribunal would have reached. Now, I accept that all the judge's findings B and C of 5A were satisfied, but A was not. So in my submission, for those reasons, the judge should simply have quashed the decision and left it at that. And that's ground 2.
Thank you.
It's accepted, as I indicated earlier, that the Secretary will in any event needs to reconsider the decision in view of the Section 55 issue. So if successful on round one, that doesn't touch. Unless there's any.
Anything else, Matt?
But can I just check, he's still here lawfully though, his discretionary leave continues until the outcome of the appeal and fresh decision. Well, it's not for us, I suppose, but that would be harsh.
I think that would be the effect of section 3C on the basis
okay.
that if the decision is quashed, then
The appeal hasn't been determined and
the application hasn't been determined. I'm not 100% sure, but I think that would be right.
it would be harsh, and I'm sure
But
you.
also there's a stay of the quashing order, isn't there?
There is a stay of the
right.
quashing order I think at the moment, my lady, yes.
Yes. So if that's the position, then his leave.
And the discretionary leave granted in the first time round would be okay. Just I didn't want him to be left in a legal limbo.
I think my lord, his application was in time, so I believe that section 3C would have.
Anyway, it may have a new thing.
I will ask those behind to just confirm that.
Right. Anything else? Thank you very much. Yes, Mr. Mackenzie.
My lord, I'm grateful. On that last point, I'm told that the respondent does have limited leave until 2027. So he's not in any sort of limbo. Leave, of course, which on the Secretary of State's reading of the policy he shouldn't have had, but he does. We'll come on to that in a moment. Obviously, we say that the transitional arrangements are key. In order to understand them, I do just want to make a couple of points on the old policy. Before I do that, it's obviously a key point of our argument that what the Secretary of State did in this case was effectively to apply the new regime to the respondent's application for ILR when the transitional arrangements, which we've looked at, made clear that he should have been subject to the old regime, the more advantageous regime. And in doing so, we say she effectively drove a coach and horses through the transitional arrangements, and indeed somewhat defeated the point of having a policy or having transitional arrangements in the first place. And as was, with respect, observed from the bench this morning, having the transitional arrangement was a policy choice which the Secretary made. She could have said, everybody now falls into the new regime. You may have thought you were on a 6-year path to ILR, but no, you no longer are on that 6-year path. But that isn't a policy choice that she made. So just briefly on the old policy, I just wanted to flag up Authorities Bundle, page 277. These, of course, are the criteria for granting discretionary leave.
277
277, yes.
in the
Authorities.
yes, that's the archive. The previous.
Yes, that's right. So this is the old policy. So these are the criteria for granting discretionary leave. As my learned friend mentioned this morning, these are different from the current criteria. They include as the first provision cases where return would breach Article 8. And so that is, of course, the criteria which apply to the respondent. And so that's his gateway into DLR, into discretionary leave. Despite having offended, or indeed because he'd offended, that's why he gets discretionary leave. He'd previously, of course, had indefinite leave after arriving here as a child. So the fact that he's offended is the whole reason why the discretionary leave policy applies to him in the first place. That's why the question of his entitlement to remain under Article 8 arises at all. And we can see in the second paragraph, just very briefly, this category, the Article 8 category, applies to both asylum and non-asylum cases. The next point I just wanted to make briefly is about exclusion. And that's page 280. So here we have the exclusion category, which make clear that a person can be excluded from discretionary leave if sorry, I've lost that. Yes, right. Yes, they can be excluded from refugee status, humanitarian protection, or discretionary leave in the first paragraph, where they would have established that they were a refugee or eligible for a grant of humanitarian protection, but for the fact that they were excluded from that protection. And then the exclusion criteria, which my learned friend took you to, include committing war crimes, committing serious offences, acts of terrorism, and so on. Not contended the applicant fell into that category. A question was raised, I think, this morning as to why not. The answer is because he was never claiming to be a refugee to start with. So this applies to people who would be a refugee but for the fact of their offending. But this isn't such a person because he's not a refugee anyway, and he'd never claimed to be. So that's why he gets 3 years and not 6 months. Again, this category could have said, as on page 277, that this applies to non-asylum cases as well, but it doesn't. So it only applies to asylum cases. You're not excluded if you're not a
Third
refugee.
paragraph, that was the issue here, exclusion from discretionary leave.
Yes. Well, I would suggest that what all that is saying is that you may be excluded from discretionary leave on the same basis as you're excluded from refugee status or humanitarian protection. And that is an explanation. It doesn't matter, of course, because the appellant wasn't placed on 6 months, but this may be an explanation for why he wasn't given 6 months and placed on the 10-year route. Obviously, this is moot anyway because he's well past 10 years anyway. I was just simply trying to illustrate why it may be that he wasn't put on the 6-month route. So the old policy, we would suggest, is very clear, as was observed this morning. Again, I'm not going to take you through this in great detail, but it's very clear that for somebody in the respondent's category, so he's not on the 10-year route, he's not excluded, if they've completed their 6 years with discretionary leave, again, assuming they haven't been sent to prison in the meantime, and as long as they continue to qualify, so they meet one of the criteria that we just looked at page 277, one of the positive criteria to be granted DL, then they're entitled to be granted indefinite leave. If they meet all those criteria, they're entitled to be granted indefinite leave. And my learned friend, I think, accepted that. And what is noticeable, we say, particularly noticeable about this pre-2012 policy, is the complete lack of any qualification or proviso based on criminality, unless you're on the 10-year route, which is not. So there is a system of exclusion for those on the 10-year route. They have to wait 10 years. In some cases, they never get ILR, according to this. But for those who aren't, there is nothing to suggest, nothing in this policy to suggest that criminality is relevant to the period of leave they should be given or to their eligibility for ILR. So for somebody on this 6-year route, as long as they continue to meet the criteria, so there's no material change of circumstances, they get an extension, and then after 6 years. And as I say, that is regardless of the fact that the whole reason their eligibility under Article 8 may have become an issue is the fact that they've committed offences to start with. So for many people, including this respondent, the fact of having committed offences is the gateway into the DL. It's the whole reason why it applies. So as I think we put it in our skeleton, the offending is baked in rather than being an additional obstacle.
Can I just ask you about the last bit on page 288, personal decision
Sorry, 280 or 288? 288.
8.
Sorry.
Personal decision.
So I think we've established that the grounds of exclusion are referred to on page 280, and those are grounds that apply to discretionary leave as well as to leave.
Yes, this is the passage which entitles ministers if they make a personal decision to deny ILR at any time.
Yeah. Now, all I wanted to ask you about is that it's on where the minister decides the person's presence in the Irish kingdom is not conducive to public good. But I just wanted to ask you, just ringing a vague bell, is there some relationship between presence being not conducive to the public good and deportation under the 71 Act and also under the mandatory deportation?
Yes, yes. That, I mean, conducive to the public good is basically the reason why you get deported.
Yeah.
Under Section 3(5), I think, of the 71 Act.
And there's a
So that's
deeming,
the
isn't there a deeming provision in the 2007 Act about?
And then there's a deeming provision that anybody who is a foreign criminal their removal is conducive to the public good. I believe that's right. Yes.
But it didn't apply to him, of course, because he committed the offence before the 2007 Act came into effect. So he was never a foreign criminal, and there was no automatic deeming.
That's correct. And in any event, he'd resisted removal because of Article 8, so he avoids all of those provisions.
And is there something in the 1971 Act about conduciveness to the public good and deportation? It's just ringing a vague bell.
Yes, in the 71 Act, do you know what they say?
Yes.
Yeah.
Yes, Section 3(5)
Yeah.
is the deportation provision.
And how long has that been in force?
Since the beginning of 1973.
Since 73.
Yes,
1st of January 73, I think.
It was all the way through.
yes, absolutely. So
Dr.
that's never
Middleton
changed.
knows
It's
how
been that's the basic architecture for
And
deportation.
it has always been.
Yes.
Yeah.
And that's what she was purporting to do, the Secretary of State, and she made a deportation notice. It wasn't automatic because that act hadn't come into force. And he appealed, and he was allowed to stay. And they said he was Article 8 because of his medical case, his connections with his child, and the fact he'd been here since the age of 5, as I recollect.
That's right. In fact, there's an additional step, my lord, because he initially loses his appeal, and then he applies for his deportation order to be revoked,
He revoked,
and
yeah.
then he wins at that point.
Yeah.
Yes, essentially. And I'm being reminded that's why he loses his indefinite leave, because
Yes, because he
the
validated
order is
it.
made,
Yeah.
and he doesn't succeed until after that. So he then doesn't get his indefinite leave back. His authority on that.
So sorry, have I missed out an appeal? So he applied for the deportation order to be revoked. That application was refused, and then there was a further appeal. Is that right?
No, sorry. He appeals against the deportation order.
Yeah.
That fails.
Yeah.
Then he applies for it to be revoked with fresh evidence, I believe.
And the Secretary of State revoked it. Is that
No.
right?
And the Secretary refused to revoke it, and then he wins his appeal.
Yes, that's what I thought.
Sorry.
Okay, sorry, my fault. I didn't ask a clear question.
And so it's because it's that sequence of events that he loses his ILR. So as I say, the old policy has no reference to the immigration rules. It has no reference to the general grounds for refusal. It has no reference to ILR as a privilege. That's the Secretary of State's current policy approach. Obviously one she's entitled to take, but it's not one that's applied prior to 2012, at least not in this policy area. And obviously that was the position at the time he was granted DL, and would have been the route to ILR on which he'd embarked. And we say it's very clear that when the DL policy is tightened up, as I think was the phrase we agreed on this morning, in 2012, that older and more benign policy is expressly preserved. So if we then turn to the transition arrangements, I know we've looked at these in great detail, but there are a few points I'd like to make about them, if I may. They are at page 271. So on the third paragraph, below the applicants granted DL before 9 July 2012. We've seen this sentence, of course. Those granted under the DL policy before 9th of July 2012 will normally continue to be dealt with under that policy through to settlement, and normally they will be eligible to apply for settlement after 6 years continuous DL. And it's not in dispute that that applies to the respondent. And my learned friend, as I understood it, placed a lot of weight on the second normally in line 3. But all normally is doing, all the second normally is doing, we would say, is summarising the effect of the old policy. That is to say, there are certain exceptions to people who certain exceptions to the rule that you get ILR after 6 years. So those who are excluded, those who spent time in prison, those who no longer meet the criteria. What the second normally is not doing, in my respectful submission, is qualifying the meaning of the old policy.
Qualifying.
The meaning of the old policy.
Right.
Sorry. And we say, as we do about the whole of this page, really, if that were the intention, that would have been made more clear, as my Lord Justice Baker observed this morning. It would have been made much more clear. And certainly the transitional provisions would not start off by saying, as they do, that people in the pre-2012 cohort will continue to be dealt with under the old policy through to settlement. If the transitional provisions meant what my learned friend says, they would make it much more plain that the old policy is being amended or that it's only being applied with significant provisos. And as to the following paragraphs, as I think we've seen, they're not models of drafting, even if, or perhaps especially if, they are directed at caseworkers, individual decision makers, rather than to be construed as statutes. But perhaps the key to interpreting them is that they do need to be read coherently and consistently with with the sentence that starts off that passage. So the policy should be read in a way, where possible, should be read in a way which is internally consistent, internally coherent, and although of course there may be policies which don't make sense on their face, the presumption should be that we find an interpretation which does, and which doesn't lead to contradictory outcomes. So we start with this general confirmation that the old policy applies, and then the paragraphs which follow that must, we say, be read consistently with that, which I believe was the point my Lord Justice Lewis made this morning. So if we then read these next two paragraphs, paragraphs 2 and 3 as we called them, in context, so in context of a passage headed transitional arrangements, on the basis that they're not intended to contradict what has just been said a few lines above, all those paragraphs are doing is saying that a further grant of DL is conditional on there being no change of circumstances. And that is clear, we would say, from the sentence in paragraph 2, you must consider whether the circumstances prevailing at the time of the original grant of leave continue at the date of decision. It's not at all obvious what that sentence could mean. If the person could be refused ILR even if their circumstances have not changed, why would it be relevant to consider whether the circumstances prevailing have changed if the person can be refused either way? And as I say, there are obviously two respects in which there could be a change of circumstance. One is whether the criteria for being granted discretionary leave at all are still in place, so whether there's still going to be a breach of Article 3 or Article 8 or another convention reason on removal. And that's not in dispute in this case. And the other possible change of circumstance is that there's been recent offending. And again, we say that's clear in context in the sentence in what we call paragraph 3, beginning if there have been significant changes. Now, as I understand it, my learned friend would have you read that sentence, the significant changes sentence, as if it said something like, if A, there have been significant changes that mean the applicant no longer qualifies for leave under the DL policy, or B, the applicant falls for refusal on the basis of criminality, the further leave application should be refused. So on his reading, as I understand it, criminality is an alternative to the significant changes. And if that's right, then historic criminality could lead to refusal. Now we say with respect that can't be what it means. We say the more natural and we say correct reading in context, as I say, is that if there have been significant changes that mean A, the applicant no longer qualifies for leave under the DL policy, or B, the applicant falls for refusal on the basis of criminality, the further leave application should be refused. So the significant changes relate either to the risk of breach of human rights on return, or which I think was Milady's point this morning, or B, to the criminal record. We say that's the only reading which is consistent with the confirmation just 2 paragraphs earlier that the old policy applies, such that ILR is normally granted after 6 years to people in the pre-2012 cohort. If it means what my learned friend says, it's not at all clear why the respondent even gets the 3 years leave, as my Lord Justice Lewis pointed out. And I would also point out that this actually isn't the way that it was put below. The way it's put below, and in the decision, is not that the transitional provisions have in some way amended the old policy. This is the way that it was put in the case of Nunez, which is the Mrs. Justice Leaving case. We haven't looked at that yet, although I will take you to it. But it's not the way that it was put in this case. If we look at the decision in this case.
But before we leave that, you say that makes sense of the 3 paragraphs read together. Paragraph 1, the old policy will continue. The old policy through to settlement will continue. Paragraph 2 really means if it is the same circumstances, you pass the criminality thresholds, that must be looking back to the things that were in place prior to 2012, and that explains why it's not exclusion and criminality, and those were met because 15 years have passed and so on, then he should normally get 3 years DL.
Yes, the criminality thresholds, of course, change over time.
Yes, but this must be referring back to those. If it's looking back and saying the circumstances remain the same,
Yes.
the level of criminality is the same, i.e. the threshold that applied then was satisfied. So nothing has changed, and therefore you get it.
Well, it could. The criminality thresholds could mean
They don't apply because they're referring back to the ones that were in place when you first got DL under the 2012, because this is all pre-2012. They would only apply if it was 4 years, but 15 years hadn't passed. But they don't apply in the sense of they've been satisfied. So the things that might have stopped you getting DL didn't stop you getting DL. It's not saying apply them again and see if you get them now. It's you got it. Circumstances haven't changed, therefore you should continue to get it. And then 3 would more naturally be, but if things have changed, because there's new offending or new circumstances, then the position is different.
well, that would certainly be an available reading, my lord. Yes, absolutely.
It helps you just in case you're worried.
I'm grateful. The point in any event is that what all of this should be doing, however one interprets it, it must be interpreted in a way which preserves the benefits the appellant previously had, the respondent previously had. That's the key to it. And however one interprets it, it can't be a reading which takes away things which he had, because if that were the intention, it would be so much more clear. And indeed, that is the point which Mr. Justice Leaving made in Nunez, which we'll come on to shortly. Could I then just go to the core bundle? And as I think we established this morning, there are 2 draftings of the decision letter in the core bundle. I'm looking at the passage at page 264.
I think we were all, most of us, looking at the earlier one.
Was it page 121?
The odd one.
121. I'm sorry.
That's what we used.
Oh, there's a further copy later on in the one.
There's 2 copies. Aren't there?
Yes.
There's more than 2.
Well, there's certainly 2. There's one that starts at
121.
258.
Well, why don't you use the internal page?
Yes.
Because we're contrarily looking at different pages up there.
Internal page 7,
Yes.
which is either 121 or 264.
Yeah.
In the second paragraph, beginning in line with Alice, so the Secretary thinks she's applying Alice here, and she applies that as authority for the proposition that Secretary of State can depart from the normal position if there's good reason. Obviously, that's not in dispute. Decision in Ellis, the end of that paragraph, recognises that its subsequent criminal conviction could plainly be a good reason to depart from the normal position. Obviously, that doesn't help her, but that's what she's quoted. And then in the penultimate paragraph on that page, she says these aspects, including the decision in Ellis, have been weighed carefully, considered under the general grounds for refusal, the nature of your criminal conviction. And end of line 4, your criminal conviction, 30-month prison sentence would result in mandatory refusal. No, sorry, I wanted to look at line 3. Supplying a controlled Class A drug is considered sufficiently serious that it remains a good reason to depart from the normal position of granting ILR under the DL policy. And then final sentence of that paragraph, the length of the sentence reflects the seriousness of the offence and is a relevant consideration in deciding that it's good reason to depart from the normal position. And that's maintained in the submissions made before Ms. Justice Obi, page 101 of the Corb under paragraph 36. So Ms. Sullivan, who's then representing the Secretary of State, accepts Part 9 of the immigration rules isn't determinist of the claimant's case, but she contends that transitional DL policy uses the word normally advisedly, preserving discretion to depart from the standard position with a good reason. Serious criminal offending is a legitimate basis for departure, and again the reference to the nature of his offence, and she submits, while Ellis involved a subsequent conviction, she argues that it doesn't preclude reliance on earlier convictions. We say that's wrong, obviously, but that's her submission. And again, cites Ellis in support of the submission that the policy is not prescriptive and that there's discretion to treat a case as abnormal. So the Secretary of State is not arguing below that, or in her decision, as it happens, that the transitional arrangements qualify the old policy. That's not her position at all. Her position below and in the decision is that implicitly they don't, but she still has discretion to depart from that norm.
So which paragraph particularly were you saying there? In the
Which
judgment,
paragraph?
in the judgment were you just saying?
Sorry, 36. This is
Yes,
the,
thank you, that's right, 36.
But two things about that. Firstly, some people might say that you're entitled to depart from the old policy. Say, for example, you had a child murderer or somebody who tried to behead a soldier. You might well say, well, I'm sorry, there comes a limit and you're not having it, so you could do it. I thought you were going to submit that you've got to get the starting point right. And it's not, oh, this is serious, therefore I'm going to refuse it. The starting point was she's already decided that she wouldn't treat those things as sufficient. And the question is, what more is there about the old thing that justifies treating it as a reason for departure?
well, that very much is our point. That,
So I thought you were going to submit.
well, yeah, it's a point I was going to come on to, but yes, absolutely, my lord, that is very much the point. I mean, in a nutshell, if you can simply refuse ILR on the basis, if you can depart from the norm of granting ILR on the basis of historic offending, then either you are treating the individual differently from other people who have also got historic offending, in which case the decision making is arbitrary and it defeats the point, as I said earlier, of having a policy at all. Or you're saying, well, we're going to treat everybody as being ineligible for ILR on the basis of their historic offending, in which case there is no point having the transitional provisions. It's one or the other, and so the Secretary of State is somewhat on the horns of a dilemma. Either there's no point having a policy because it's the decision making is inconsistent, or there's no point having the transitional provisions because you're applying the new regime to everybody anyway. So indeed, as my lord has said, there does need to be something more about the offending, and absolutely we would accept that in extreme circumstances such as those, that could very well be the sort of reason one is looking for.
But isn't the question whether there is something more about the offending a matter for the Secretary of State?
Yes, but it's not something she's ever said in this case. We're talking
And
about
you say that's why we've got to remit. She might come back and say, well, I've thought about this. This was 30 months. He was actually supplying to children under the age of 14 or something. She might do it, but she's got to start off with the question. And in my policy, I would not usually treat even something as dreadful as 30 months conviction for crack cocaine.
Yes.
I do know, but I couldn't then. So why am I treating that differently now? She'd have to ask a slightly different question.
She'd have to start from a correct understanding of the policy. Yes, absolutely. And she would have to ask a different question from what she has asked. Yes.
But there could be circumstances in which looking at historic criminality now would entitle her to refuse leave
Yes, and
because it's reviewed now as opposed to historic. You're reviewing historical. She's reviewing a historical offence in the current context, and one can imagine there will be circumstances, certain types of offences, which would justify a different treatment.
that might well be so, but it's not something she's ever argued.
Yeah.
And we'll perhaps deal with this when we come on to the question of remedy, but
Yeah.
we haven't excluded, and the judge's order doesn't exclude the possibility that there might come out facts about the offence which the Secretary of State was not aware of,
Yeah.
such as, yes, it was being supplied to children, although one would suspect probably not on the 30th
No, that's all hypothetical. Your client must
All
not
hypothetical.
think that. It's all hypothetical.
Yeah, absolutely. But there might be other matters which would come out, and the judge is left it open to the Secretary of State to decide that.
So can I just be clear about your submission, please, Ms Mackenzie? You are accepting, I think, that under the policy properly construed, the fact that the offending is historic and has already been taken into account does not necessarily mean that it can't be taken into account when deciding whether or not to grant ILR. Is that your position? I just want to understand.
There would need to be something different about the offending. What one can't do is say that the offending which has put you in the DL policy to start with, and which is baked in, as I said earlier, to your 6-year path to ILR, is then a reason for refusing you ILR, bearing in mind the preservation of the 6-year path by what we say is the preservation of the 6-year path by the transitional arrangements, because you're then either, as I say, you're then either in the territory of saying, well, everybody with historic offending up to over a relevant threshold is refused, in which case there's no point having the transitional provisions, or this particular individual is refused because of a type of offending which he has in common with everybody else anyway, so that's not a valid point of difference.
Sorry, I just want to be clear what your submission is. So your submission is that historic offending can be relied on, even when it's been relied on before, but only if you now know something new about it.
No.
No, I'm just trying to understand it.
I'm not excluding that would be a possibility. Yes, if there was something that came out about the.
Well, doesn't it all come back to your original point, which is something I put to Mr. Anderson this morning, which is that one has to compare and contrast the context of the two paragraphs on page 271. The first question is whether the circumstances prevailing at the time continue.
Yes.
That's category 1. And the second is whether there has been significant change,
Yeah.
which in your view qualifies not only the first part of that sentence, but also the fact the applicant fails for refusal on the basis of criminality.
Yes.
Could it be said that the proposition you're considering now is whether there has been a significant change in the perception of the criminality or the criminality which would justify refusal?
That under her current approach to criminality in the immigration context, the Secretary of State could take a more severe view of the same criminality.
Yes, for a variety of reasons. I'm trying to think of an example.
Or death by dangerous
Hate
driving.
crime.
Hate crime.
I think things that were treated are regarded more seriously 20 years on. Hate crime,
Coercive control with.
yes.
Well,
Point is, there has to be a significant change.
I think I would nail my colours to the mast of there having to be a significant change either in the circumstances or in the facts, as opposed to the minister's view of the crime.
Your point, I think, is it's not enough to say, is this a serious crime? I have a discretion. They've got to approach that from the point of view where they've already accepted that crimes generally, before the DL grant, are not going to disqualify you.
Yes.
So you have to approach it not just, I've got a discretion, is this a serious crime? You've got to approach it on the basis, this is a serious crime. My policy hitherto has been still to grant ILR for this small cohort. What is it about this particular set of circumstances that causes me to depart from that?
Yeah.
That's your position. I think
Yeah.
you've got to build into the equation somewhere recognition for the old policy and the fact that rightly or wrongly she was generous to people in the past. That's your
Yes, absolutely, and one has to look at these policies in the light of the approach that was being taken at that time, and obviously attitudes of the government to offending in the immigration context have changed vastly since 2012. And we have the
not enough to
2040.
say this is serious.
Yeah.
You've got to say we treat this more seriously now than we used to.
Yes, absolutely.
Yeah. But that does, the way my lord just put it then, incorporate possibly not something new and discovered about the offence, but a different perception of the offence.
Yeah.
But you wouldn't share that view.
I wouldn't respectfully go that far. I don't think it.
There's no reason. It
affects
doesn't
me
affect you in
anyway.
this case either way, does it?
No, we would say it doesn't affect me anyway, and maybe the kind of question which needs to be reserved for a case where it does matter.
Agreed. But the key point is significant change, as opposed to circumstances prevailing at the time.
Yes,
That's the
That's another.
the key to understanding these paragraphs.
Yes, absolutely.
He knew a factor other than the mere fact of having committed the crime.
I don't.
A factor other than the mere fact the person has committed the crime.
Yes, absolutely. Yes, I mean our approach is reinforced by the cases, which I'll come on to in a moment, both Ellis and Nunez. And as I say, my learned friend's approach effectively invites the court to read these transitional provisions as giving with one hand and taking away with the other, and we say that that's not the correct approach. Indeed, as I believe my Lord Justice Lewis pointed out this morning, on one view, the new policy makes things worse for the respondent because he shouldn't have had leave at all. And again, one would expect that to have been flagged up very clearly. As I say, this was a policy choice made in 2012 and maintained since, of course. Again, the Secretary could have withdrawn these transitional arrangements each time she reviews the policy. She never has. And at its heart, what the Secretary of State seems to be doing is trying to reverse that policy choice, either in respect of this particular individual, or potentially, it would seem, for everybody in the pre-2012 cohort, I'm not sure which, by interpreting the transitional provisions as if they didn't preserve the old 6-year route, either for this individual or generally. As I say, if the Secretary doesn't like the consequences of these policy choices, she can change the policy. It is open to her to do so. If she thinks it ought to be tougher for everybody to get ILR, regardless of when they first got discretionary leave, she can make it tougher. She doesn't need to appeal to this court to be rescued from the consequences of her policy choices. Albeit, of course, we would say that if she did change it, it would come too late to preserve the decision which she actually made. Could I then come on to the cases? So starting with Ellis, We say that it's authority that change of circumstances, as of course we accept, specifically fresh offending, may be a reason for refusing ILR by way of departure from the norm. What it doesn't do is leave open the possibility that historic offending would be sufficient to deny ILR. And we say that if Mr. Justice Chamberlain had considered that it could be sufficient, that if historic offending could be sufficient, he would have expressed himself with respect very differently. We've set out paragraph 27 onwards to ask why that is so. Ellis is tab 9 of the authorities bundle. And at page 132, Mr. Justice Chamberlain goes through the true construction of the DL policy. I believe the court will have looked at this already, but so I'll go through it very quickly. The end of paragraph 40, the last 3 lines or so of paragraph 40, he says a reasonable literate reader would understand that, at least in a normal case, an individual has already been granted 3 years DL will be granted a further 3 years DL on the second application and ILR on the third, i.e. after 6 years. 41, caseworkers should consider whether there are circumstances that warrant departure from the norm. Policy doesn't specify what might justify such a departure, but a criminal conviction since the last occasion could, in principle, plainly do so. So, first of all, the judge, 2 points really. First of all, the judge is confirming both that the policy doesn't on its face permit historic offending to be a reason for refusing ILR, and the second is that he's also saying historic offending is also not a reason for departing from the policy. So both of the approaches that my learned friend seems to be pursuing are ruled out by Ellis, we would say, even though the Secretary of State's position, at least below, was that Ellis was correct. 42, his lordship goes on to discuss the possibility of departing from the policy as long as the decision maker, top of page 133, last 2 lines of the paragraph, as long as the decision maker takes account of the policy and has a reason for considering the case to be abnormal. So very much in line with the discussion we just had.
Remind us at some stage that the decision maker forgot to include paragraph 2 in the quotation that she set out in the decision letter, so she can't have considered that bit.
Well,
or if she did, surprising she didn't put it in.
Yes, absolutely, my lord. And the learned judge's position is even more clear if one looks at 53, which is page 135. The court may have had a chance to read this already, but essentially at 53, his lordship makes abundantly clear that it's the recent offending that he regards as a reason not to grant ILR, and equally clear that if it were not for the recent offending, he would not have seen the historic offending as sufficient. And as I say, it's on Ellis that the Secretary of State relies in her decision, as we've seen. As I say, she seems to regard Ellis as correct, although she actually does what Mr. Justice Chamberlain plainly regarded as insufficient. And the reading of Ellis that I've just set out was also the one reached by Mrs. Justice Levin in Nunez.
No, we haven't looked at that yet.
No, that's tab 13.
Nothing, he's got the PTA.
And at page 233 of the authorities bundle.
Yeah.
Paragraph 36, her ladyship says that the important point about Ellis for present purposes is that if Mr. Tabori, Secretary of State's counsel, was correct, Mr. Ellis could and probably should have been rejected on the grounds of his pre-2012 criminality. So this is again a case where we have historic criminality in the if Mr. Tabori's argument was correct, then it wouldn't have been necessary for the Secretary of State to find other reasons for departing from the normal position. Mr. Tabori accepted that if his argument was correct, then it meant that both counsel for the Secretary of State and Mr. Chamberlain hadn't properly understood or applied the DL policy. There's then a discussion at 37 of the two uses of the word normally, which Her Ladyship says line 5 does not matter because she says line 6, the fact remains that if Mr. Tabori's argument was correct, Mr. Ellis could have been refused on the basis of criminality grounds and the procedure rules. Position wasn't taken by the Secretary of State. Justice Chamberlain, Secretary of State through counsel made an express concession that the 2012 policy applied necessarily so that the criminality grounds could not be applied, i.e. could not be applied to the historic offending. And then over the page, Her Ladyship summarises the submissions of counsel, so paragraph 38.
What is the submission by Mr. Southey that she accepts? 43.
So this is what he says at 38 and 39.
Yeah.
So Mr. Southey, his counsel, is submitting at 38 that the terms of the transitional arrangements in DL policy are clear. Individual will be entitled to ILR if they've had DL since before 9th of July 2012, unless A, they fall within the restricted leave policy, which doesn't apply here, or B, there's been a change of circumstance. So that's essentially our argument, accepted by Her Ladyship, as
Right.
well as I said at 43. And then at 39, Mr. Southey goes on, the entire thrust of the transitional arrangement says that the presumption in favour of further ILR, which would have arisen before July 2012, unless there's been a material change of circumstances. This accords with the principles of fairness. It would be unfair to deprive somebody of the ability to get ILR by changing the policy after they've commenced on that route. And then at 41, she addresses the submission of Mr. Tabori for the Secretary of State, and he submits that all of that is a misreading of the transitional arrangements. He focuses line 2 on the sentence, if the circumstances remain the same, the individual doesn't fall within the restricted leave policy and the criminality thresholds don't apply, for the period of 3 years DL should normally be granted. He submits the sentence outlines 3 exceptions to the general position, i.e. the general position of people being normally dealt with under the old policy. Line 8, he says the first excluded category is those with restricted leave. Second, those where there's been a material change of circumstance. And third, those where the criminality thresholds apply. In the Southey case, he submits that there are only 2 exceptions because the criminality thresholds only apply where there's new criminality. And that's rejected. And as I say, that's not the reading of the policy advanced for the Secretary of State, in this case by Miss Sullivan below. As I say, the submission there was that the policy did not envisage refusal on the basis of historic criminality, and therefore to do so would be to depart from the policy and not to apply it. I'll take you to the passage earlier. So just 6 days apart, these 2 hearings are just 6 days apart, as I recall. The hearing in this case was the 5th of November last year, and the hearing in Newman, I think, was the 11th of November. The Secretary of State is adopting 2 somewhat different approaches to the policy. And Mrs. Justice Lieven then rejects the interpretation of the policy being advanced by the Secretary of State. That's page 235 in the sidelined passages, which the court, I think, can see. I mean, I don't know if the court wants to take a moment to read those sidelined passages.
5 minutes, if you read it. Have you read them, Lizzie? Optimistic about repeating my petrol's guy. Right, okay, we've read that, and no doubt you're going to, well,
Yes, well,
we
we say
won't anticipate what you're going to say, but
we say it's correct, of course. We say with respect, it's correct, it's compelling, it's clearly the intention of the Secretary of State when she's implementing the transitional provisions.
you reiterate Mr. Southey's submission
Yes.
about the clarity of language that we're required to achieve the aim the
Uh,
Secretary of State advanced.
Absolutely, and indeed that was the point my lord made this morning. Absolutely. Secretary of State would have, well, she didn't even need to have transitional arrangements if the approach she was advancing there was correct. She could have dispensed with the transitional provisions entirely. Indeed, it's quite unclear on her case what the function of the transitional arrangements is if she can simply apply.
Just give me a moment, Mr. Gibbs.
I haven't fully got, and I wonder how important it is, apart from a jury point, that the Secretary of State said one thing on Monday and another thing on Tuesday. One of my finest hours was in a case where the Secretary of State said different things in the same case to me. And I was the claimant, I said, well, I must win on at least one of the two cases. But I haven't got it, and if it's important or if it's just a jury point.
Well, it's not so much a jury point, it's just I'm not entirely sure which case I have to answer, I suppose.
Just tell me what they were arguing in the Nunez case and what they were arguing in this case and why they're different.
No, what Milena Friend has argued today appears to be the same as what they're arguing in Nunez.
That is an automatic, doesn't
That's not
apply
what-
because.
But that's not how they put it below.
Not how I put it below.
No,
And I'm not.
that's the difference then, yes. It's an automatic exception now, whereas down below they were saying what it's
A departure.
a departure,
And
yes.
did that feature in the judge's judgment?
Well, that's the case she addresses in her judgment. Absolutely, yes. The argument being advanced in Nunez is not addressed by Ms. Justice Obi. That's not the case that was put to her. And I'm not entirely sure whether the case being put below by Ms. Sullivan is still a case I need to answer. I'm very happy to try and answer it. Obviously, I say insofar as the Secretary of State is now arguing that the DL policy encompasses on its face, through the transitional provisions, the possibility of refusing ILR on the basis of historic offending. We say that's clearly wrong for the reasons we've been discussing. It runs a coach and horses, as I say, through the transitional arrangements. If the Secretary of State is still arguing that even if that's wrong, she could achieve refusal of ILR by way of departing from the norm, again, we say that's equally without merit. I do have submissions on what normally means in this context and in what circumstances a public authority can depart from a norm, if that will be helpful, but I don't wish to take up the court's time.
Well, I think it might be helpful, just so we've got all bases covered.
Well, I'll try and be fairly brief. I mean, the starting point, in my respectful submission, is that this policy, like any other, exists in order to provide consistency. The passage we quoted in our skeleton at paragraph 10 is from Lord Reed in the Tesco case, where he talks about policies existing in order to guide the behaviour of decision makers and to secure consistency and direction in the exercise of discretionary powers while allowing a measure of flexibility to be retained. I don't think we need to go there because I don't think it's controversial, but it's page 80, paragraph 18, 1.8 of the authorities. Lord Justice Laws put it in Nadaraja in a passage I perhaps would like to turn up at page 51 of the authorities binder. And his lordship talks there about.
Will you quote this in your skeleton?
Yes, indeed. So adherence to policy is a requirement of good administration by which public bodies ought to deal straightforwardly and consistently with the public. Expressly obiter words, but frequently cited by the Supreme Court and Privy Council. And then at the end of that paragraph, his lordship talks about departure from a policy must be a proportionate response of which the court is the judge or the last judge, having regard to a legitimate aim pursued by the public body and the public interest. It's perhaps worth noting in that context what the policy under discussion was And we can see it at page 22, paragraph 7. Policy referred to as the family links policy, and it concerned whether asylum seekers should be permitted to remain in the UK to seek asylum rather than being required to return to a third country. And the relevant passage is set out there at paragraph 7, page 22, and we can see that it's quite broadly framed, substantial area of discretion in the first line. Third line, broadly speaking, however, the approach we propose to adopt as potential third country would normally be considered substantively, i.e. allowed to claim asylum in the UK, where A, they've got a spouse in the UK, B, they're an unmarried minor with a parent in the UK, C, they've got an unmarried minor child. And so in one of the cases before the court, there was a dispute as to the appellant's date of birth. So was she a minor or not, and therefore did she fall within B? And the other case, which is Mr. Nadaraja, the dispute is whether the appellant's wife is an asylum seeker. Now, the Secretary of State understands asylum seeker in that policy to mean somebody with an outstanding initial claim. And Mr. Nadaraja's wife has a outstanding appeal, so she's been refused asylum. Secretary of State says that means she doesn't, and therefore he doesn't, fall within this policy. The judge below, which I think was Mr. Justice Stanley Benton, finds that's wrong. And we can then see at paragraph 10, page 24, that the Secretary of State then changes the policy to make clear that it is only somebody with a outstanding initial claim, so not somebody on appeal. So that defeats Mr. Nadaraja's point, essentially. And as to the significance of words like normally and broadly speaking, Lord Justice Laws addresses these at page 36, paragraph 38. And he says that in making submissions about the policy, Mr. Underwood, the Secretary of State, laid some stress on the loose and general terms in which it was drafted. Broadly speaking, normally discretion would need to be exercised, etc. And his lordship says, line 5, there may well be instances in which these features of the policy would be important, but they provide no carte blanche for the Secretary of State simply to choose in any given case whether to apply the policy or not. In fairness, Mr. Underwood didn't submit as much. Generally speaking, the discipline of reason in fairness that the law imposes on public decision makers obliges them to apply a stated policy to those whom it's directed. If it sought to deprive an individual or class from the benefits of the policy in question by recourse to formulations such as broadly speaking or normally, there will have to be a reasoned justification. Here, that stage was never reached. And it's in that context that Lord Justice Laws then later in the judgment makes the remarks that we quoted in our skeleton about justification meaning proportionate, having regard to legitimate aim. And as I say, those are remarks which have been frequently approved, including in Mandalia, which you have in the bundle. So to that extent, we say it makes no difference whether the policy states on its face that it's setting down a practice which is normally to be followed, as in this case, or as in Nadaraja itself, or whether it appears in its face on its face to express matters more unequivocally, because there's always discretion to depart from the norm, whether the policy says so on its face or not. And the point which, in my respectful submission, Lord Justice Laws is making there is that adding in words like normally doesn't expand the public authority's freedom of action. They can always depart from the norm.
Yeah, so the first thing you want to do is to establish what the policy means,
Yes, absolutely.
and the circumstances in which it applies on its language.
Absolutely.
So that's the first issue of interpretation, and then there's a question about, has the Secretary of State on the facts of the particular case departed from the rule of the policy,
Yes.
and has she explained why?
Yes, absolutely. And in the formulation in Nadaraja, it's has she done so in a way which is proportionate to a legitimate aim?
But what words like normally and so on don't entitle the decision maker to do is to make up a policy which is different from the policy that's stated in the relevant policy document.
Absolutely, and they don't entitle the decision maker to reach a decision which, as I say, runs a coach and horses through the purpose of the policy to
Well,
start.
it's a different way of putting the same point.
Indeed, my lord, yes, I'm sorry, yes.
And the third way, to put the same point, is the question is not, if you're right on the interpretation of the policy, the question is not, is there a good reason for refusing ILR? Because many people might say, yes, he's a criminal.
Yeah.
The question is, given that the policy says you normally get ILR, even if you've got previous offending, is there a good reason for departing from that policy?
Yes.
And the two things are quite different.
Yes, it's the good reason for departing, not the good reason for refusing. Yes,
Yeah.
exactly, indeed.
Because that's built in the factor that favours not departing the following.
Yes,
Right.
I spent some time, I have to admit, looking for authority on how one measures the lawfulness of a departure from a norm. And there seems to be relatively little guidance. One case which my own friend in fact cites is the Duke of Sussex case, and if it will assist, I'll just take court briefly to that, but it does give us some indications of the circumstances in which a departure from the norm is appropriate.
Yes.
It's tab 12, starting at page 204.
Yes.
And as the court may recall, this was all about whether the security arrangements for Prince Harry and his wife
Yes.
were appropriate. And so a body known as RAVEC, RAVEC, was responsible for determining security arrangements for members of the royal family. It operated policy guidance, which provided for it to evaluate a risk analysis when deciding who within the royal family needed to receive protection, and it hadn't done that essentially in the case of Prince Harry. So the question was whether RAVEC was entitled to depart from that aspect of its policy, to depart from the policy which said we need a risk assessment. And the Master of the Rolls deals with this at page 221, paragraph 64 onwards. The person referred to here is Sir Richard Mottram, who is the chair of the relevant body, RAVEC, or had been the chair, sorry, at the relevant time. And the Master of the Rolls identifies a number of factors relevant to whether the departure from the policy is lawful. So the first is said to be at 65 to relate to the nature of the policy itself. The Master of the Rolls refers to a spectrum in line 2, which ranges from the most formal policies made after public consultation under a statute at one extreme to the most informal internal-facing guidance, such as social media policies and good law project, towards the other extreme. And the policy relevant to the Duke of Sussex, at line 7 of that paragraph, is said to have concerned an area of national importance, but was peculiarly within the expertise of law enforcement agencies rather than the royal household itself. 66, the second connected factor, is the deference that the court ought to pay to the decision maker in deciding whether it has good reason to depart from its policy. Over the page, line 3 of the page, page 222, the required deference in relation to whether or not the decision maker had a good reason is also on a spectrum. At one end, there'll be reasons given for departing from policies on the most sensitive issues of national security, where the court can rarely second-guess the expertise of government agencies, and the other will be run-of-the-mill decisions on routine cases, perhaps on immigration, or benefits issues, where deference to the expertise of the decision maker may be less obviously required. 67, the Secretary of State is wrong, end of line 1, to say that the court can only review an authority's decision for departing from a policy if it's Wednesbury unreasonable. Good reasons to depart from generally applicable policies followed in immigration cases, for example, would obviously be susceptible to review if they weren't justifiable. Then 68, in considering whether the decision maker had good reason for departing from a policy, one considers first where on the spectrum of the policy one lies, and where on the spectrum of the deference to the decision maker, the particular type of decision lies. And clearly in that case, we're talking about a policy which was relating to a matter of national importance, very directly to a matter of national importance, the security of obviously a very high profile, or particularly high profile, member of the royal family, which, as we've seen, was said to be peculiarly within the expertise of certain specialists. And the decision maker himself, Sir Richard Mottram, was an experienced security specialist, of whom it's said at 71. His line 2 of 71 expertise and experience in the field of royal protection is probably unrivaled. And obviously, careful, individualised assessment of any risk to the Duke of Sussex and Duchess of Sussex was plainly needed. Obviously, this case, our case, is a very different one. Not a situation where personal deference needs to be paid, not a situation where the decision was particularly nuanced, or where the individual decision maker was particularly specialist. Indeed, as we've seen, the Master of the Rolls gives immigration decision making as a paradigm of the sort of case where relatively little deference is required. And obviously the question of what precise status somebody gets if they're entitled to remain in the UK, whether they get ILR or just a period of further limited leave, very much of a different order to whether the son of the king is exposed to harm. The quality of the reasoning seems to be relevant. One looks over page 72, page 223, one can see that the steps being taken have been explained in clear terms to him, and 73, line 3, compelling reasons have been given by Sir Richard Mottram for his decision. Another factor which may have been relevant, albeit not on the facts, is where the departure leads to arbitrary or inconsistent treatment, and that is dealt with a little bit earlier at 220, page 220, paragraph 58. So the subheading above 58 is also Richard, by comparison with others protected by RADAC, to have placed the claimant in the other VIP category. The other VIP category was a category for lower profile, relatively lower profile members of the royal family. And Master of the Royal says it's difficult to deal with this in open judgment because the argument depends on the comparison between the position of the claimant and the position of the other person protected by RADAC. None of those persons is directly comparable to the claimant, whose position wasn't as unique. Approves the finding of the judge below, Mr. Justice Laing, finding that there were material distinctions between Prince Harry and the other supposed comparators. So the Master of the Roll doesn't say it would have been irrelevant if departing from the policy had led to differences between treatment of the Prince and other people. He simply says there were no people in a similar situation. And of course, support for the view that arbitrary or inconsistent outcomes may be a reason why it's not justified to depart from a policy derives from the purpose of having a policy in the first place, i.e. the need for consistency in the cases that we looked at. So that's why we say that the reason for the departure must, as a matter of principle, be some feature of the person's circumstances which takes them out of the norm, which explains the differential treatment, not a feature that they share with other people. And returning to Nadaraju, if the test is a proportionality test, weighing the rights of the individual against the public interest, well, the public interest, presumably in this case, would be the deterrence of crime, by ensuring that criminality has consequences for one's actions, for one's immigration status, I should say. But of course, in this case, we would say that would find on the fact that the Secretary of State has put in place and maintained a policy which effectively says the public interest does not require, as a rule, a refusal of ILR to people in the pre-2012 cohort, or at least works on the basis that the prejudice to them by diverting them from the path that they were on would be disproportionate. So again, the public interest is built into the transitional provision. It can't act as a reason for departing. Can I then come on to what Miss Justice Obi herself makes of this, and then I'll
Yes.
look at the medical claims policy and then briefly address you on ground too.
Yeah.
So the judge's reasoning on the DL policy is set out at Ordering Court 103, page 46 on, sorry, paragraph 46 on it. And just to reiterate, the question before her is whether ILR can be refused by way of departure from the policy, not, as I said, the way in which so that does obviously affect the way she expresses herself. So her ladyship starts by taking paragraph 56, the old policy as a starting
Yes.
point. She notes the provision about where a person is held discretionary leave for an appropriate period, 6 or 10 years, and continues to qualify for DLR, there should be granted ILR/settlement. 47, she says the old policy, the pre-2012 policy, contained its own criminality and exclusion provisions. She notes the contents of the old policy, which we've looked at. And then over page 104, third line on the page, she says these provisions are self-contained. And then the last couple of lines of the paragraph, a natural reading of the DL policy is that it underscores both continuity and predictability for those on the transitional route. 48, she notes, of course, that there's no further offending. 49, she notes that the Secretary of State repeatedly granted extensions of leave, and line 2 had accepted that the conviction didn't disqualify him from the 6 years. And then perhaps I could just invite the court to read the rest of 49.
And you say that's right.
Absolutely, yes. We say with respect plainly correct, plainly in line with principle. Purpose of the policy in general is to promote consistency. Purpose of the transitional provisions in particular is to promote continuity. Indeed, it might be thought the preservation of past benefits is, as a broad rule, the whole purpose of having provisions. When a rule or a policy or indeed a statute is changed. The transitional provisions state in very clear terms that the old policy continues to apply, and we know that in the old policy there was no reference to historic criminality as a reason for refusing ILR. And we've set out, I think I probably should repeat it because we've done it on a number of occasions, but we've set out at paragraph 40 of our skeleton onwards that it undermines all of these purposes, undermines the purpose of the transitional provision, leads to arbitrariness if the Secretary of State can behave in the way that she has done, either with respect to this particular respondent or to members of this cohort generally. Indeed, it's not entirely clear, we say, what the Secretary of State says the purpose would be of preserving the benefits of the old policy by way of the transitional provisions, because if she is correct, then those in the old, the pre-2012 cohort would be in the same position as people in the new cohort. We say the judge is also correct to say that applicants can't know from the face of the policy that historic offending may be regarded by the Secretary of State as a reason for denying ILR. The policy doesn't say that. And perhaps more importantly, they can't know whether it would be regarded as such in their particular case. They can't know what factors would or would not lead to ILR being denied on the basis of on the basis of historic offending in any particular case. And as the judge, we say, correctly accepted, that would deprive them of any clear understanding of the applicable policy, compelling them to incur significant fees on a speculative basis. So essentially we say Ms Justice Toby didn't, in her interpretation of the policy clearly does on its face require a grant of ILR for people in the respondent's position, absent lawful reason to depart from the norm. She also didn't in finding that in this case the Secretary had unlawfully departed from the norm. She was correct to find that departing from it for the reason given would lead to arbitrary distinction, which was not an appropriate reason for departure. So that's the first part of ground one. On to the medical claims policy.
Yeah.
So I don't recall if we looked at that in detail, but can I just ask the court to go to Authorities Bundle 322.
322.
Sorry, it starts at 322. 357 is the passage.
Ah. Yes.
So at the bottom of 357, we have the heading granting further periods of limited leave or indefinite leave. And it stresses, so that this is important for context, which the learned judge took into account. Given the high threshold and nature of cases granted on the basis of a medical condition, it should only be in exceptional cases that a further period of limited leave is required following the initial grant. And it should be extremely rare for a claimant to have accrued the relevant period of leave necessary to meet the requirements for a grant of ILR. Then it goes on to stress that the criteria for a grant of leave on medical grounds must still be met. But it's worth perhaps stressing that we are, of course, talking about people here who are, by definition, seriously ill. That's why they're in this policy to start with, who one might expect to be treated perhaps a little more benignly than people who are not. And against that background, the passage dealing with ILR is at 358. So in the third paragraph on 358, if following a period of limited leave to remain, the claimant applies for settlement, the application must be considered in line with the immigration rules. Some people may be excluded from applying for settlement due to their character, conduct or associations, or being a threat to national security, criminal record, or security issues. That seems to duplicate the second part of the first bullet point, but that doesn't need to concern us. However is an important word, we say, when a claimant has held DL for 10 years or 6 years under the transitional provisions of DL policy and continues to qualify on the same basis as the last grant of DL, you would generally grant ILR unless there is a compelling reason not to do so. You must refer to the guidance on discretionary leave for consideration of ILR applications. And we say, this is paragraph 57 of our skeleton, that very clearly divides people again into two cohorts. A category of people, firstly, to whom the immigration rules apply and who may be excluded from ILR because of, amongst other things, their criminal record. And then, separated by the word however, a category of people who have discretionary leave, including those such as the respondent who have previously to whom the immigration rules and the bar on settlement don't apply, but rather who are generally to be granted ILR unless there is a compelling reason not to. And of course, compelling reason, we say, is a somewhat higher threshold for refusal than the one that appears in the DL policy.
So compelling is a higher threshold then?
The one that appears in the DL policy. So we say that clearly indicates that the possible reasons for refusing ILR, which would refer to the first cohort, the pre-however cohort, as it were, such as having a criminal record or even presenting a threat to national security, don't apply, or at least don't necessarily apply, to the second cohort, because they are subject to a stronger presumption of ILR, which is defeated only in where there are compelling reasons. Now, if we look at what the Secretary of State made of that, her decision is at page 122 or internal page 8 of the decision letter. So that's either 122 or 265 of the core bundle. And she cites that passage. We can see that in the second half of the page. Middle of the page, really. And then the penultimate passage, paragraph on the page, she says, end of line 1 of that paragraph, as these provisions expressly refer back to the DL policy, the assessment of eligibility for settlement remains governed by the criteria and principles set out in the DL policy. And she says, accordingly, the medical claims policy doesn't alter the conclusion reached under the DL policy as set out in the terms of the medical leave policy above and the DL policy. Your criminal conviction is considered a compelling reason not to grant ILR. As Justice Obi deals with this at page 104, paragraph 51 onwards. Perhaps I could just ask the court if you haven't already to read 51 up to 54, please.
I think your point is that the judge is right to distinguish between the medical claims policy and the other policy because its terms are different.
Yes, absolutely, yes. Yes. So the Secretary is clear.
The decision is simply wrong from the plaintiff.
Yes, absolutely. And the judge follows that at 61 by saying that both under the transitional DL policy and on the medical claims policy, the claimant as he then was entitled to succeed. And again, yes, as my lady says, we say that was essentially correct. As we said at paragraph 58 of our skeleton, again, first, whilst this isn't a model of transparent drafting, compelling reason clearly does add something to the policy. It's a higher threshold, as my lady says. Secondly, it's clearly correct to say that the medical claims policy anticipates that medical cases may involve some adverse history, as the judge put it. Hence the express reference to criminal records and character conduct and associations, etc. But it still mandates a presumption of ILR for those in the 2012 cohort.
So it recognises that different considerations may apply if
Yes.
not in that case. But this medical claims policy recognises that different considerations may apply to people who are not in the
Yeah, sorry, that's what I intended to say. I apologise if that's what I meant to say. And again, if one treats historic offending per se as a reason for refusing ILR, again, one effectively folds the second cohort into the first cohort. So the second cohort becomes meaningless because everybody is treated the same. Again, we say that's not a natural reading of the policy. Again, unclear what the purpose would be of making an exception for those in the pre-2012 within the medical claims policy. Unclear what the purpose of that would be if people in both cohorts could be refused ILR for exactly the same reasons, albeit dressed up in the language of compelling reason. And the Secretary of State's approach essentially invites you to elide the two cohorts and to ignore the indication which is given not only by the structure of that passage we looked at, but also the use of the word however to separate them out.
Right, does that leave ground two?
Yes, it does indeed, my lord. Now, We, of course, acknowledge the general principle, the appropriate remedy in cases such as this is quashing, but of course the courts do retain the discretion to go further in appropriate cases. My learned friend has already taken you to the order, if you require to look at it against page 92, at the bottom going over to the top of the following page. And it was carefully calibrated, paragraph 3 is the one we're concerned with. It was carefully calibrated to say no more than that on the material now before the defendant, the only lawful decision is a decision. And that was the logical
Let's just get the order in front of us. Yeah, thank you. Carefully calibrated.
Yes, carefully calibrated to say no more than that on the material now before the defendant. We say that's the logical consequence of the judge having found that the policies in question did strongly mandate a grant of ILR and that historic offending, which is the reason given for not doing so, wasn't capable of being either a sufficient reason for departing from the BL policy, that's being the argument then put, and moreover couldn't constitute a compelling reason for refusing the medical claims policy. We say it's entirely proper for the judge to rule that the Secretary of State would not be entitled to come back with a different set of reasons which she could have deployed already, bearing in mind the context, of course, that this is the third decision under that she's made, the decision under challenge to the third one.
Why does that matter? If she keeps getting it wrong, we send it back and eventually one day she'll get it right. The point is, she's got, on your case, the policy round her neck. We'll unwrap it, send it back to her, and she'll apply the policy. But you can't punish somebody and say you had 3 goes and you've fouled up and therefore you're not getting a 4th go. That's not public law, is it?
Well, we say the judge was entitled to say that she mentions delay as a reason for making the order that she did, and we say that was within her. Sorry.
He's been here lawfully. Yes, he, on your case, might well have got that. You know, it's not a punishment and it's not a delay, and therefore you have the court take the decision for the Secretary of State. There is a constitution.
What options did the Secretary of State have on this under this order?
Under the order as worded,
Yeah.
She could go away and either grant or refuse on the basis of material which was not previously before her. So if there'd been
Assume the same material. What options did she have?
she has to grant.
That's the question.
What's the difference between how do you distinguish that from a mandatory order then?
Well, I would accept that there's not a great distinction if one is in the territory of there being no fresh material. But
She's only got 21 days in which to dig up fresh material. She's got to issue and implement a new decision within 21 days.
yes, although there could have been material changes in the meantime since the previous decision.
Do you see?
So
Sorry.
I couldn't rule out the possibility that you'll win, it'll go back and she'll say to herself, well, yes, I've got to have a reason why this offending is more serious. And it was, because I just think drug dealing and crack cocaine is too shocking. It destroys many lives. And then you might come back and say, no, that's not proper. But she's got to have the chance to consider that. It's not just new material. It's approaching the existing material on the right position. Say it had been a different set of facts in the child killer case. She'd have to be able to consider whether that applying the policy normally was okay. So we can't assume the outcome. We may have educated guesses, but that's the whole point of remitting, isn't it?
Well, my lord, I do accept that, of course. I suppose that's why it's relevant that this was the third decision. So at no point had she previously said there is something specifically about this offending which I find particularly distasteful or
She doesn't
troubling.
think she has to, but you're hoping we'll tell her she's got to.
a bigger report.
Why does she need to have? Why do you need? Let's have a look. Why do you need paragraph 4? Why? I suppose they stand or fall together.
Yeah.
Why isn't the judgment to give a clear enough steer as to the court's interpretation?
Well, the reason she gives in her judgment is that she's concerned about delay, and there have been, as I say, there have been 3 decisions. The proceedings have been on foot for about 18 months by that point. I believe the first decision was made in April 2024. So she's concerned that she doesn't want the Secretary of State to come back with a further decision making the same point. And of course, that is also linked to the point that she's made about the impact on the child.
And also, it's because she considers that the only lawful decision on the material which was before the Secretary of State was the decision to grant ILR.
Yes, at least on the material available.
Yeah. So she thinks this is a case in which there is only one answer.
And we say she was right.
She's had several goes, so she can just come up with the right answer within 21 days. That's
Well,
essentially.
we say that she was right to say that there was only one answer on the material then available.
Sorry, no, go on.
Well, she could say that in the judgment without going on to make the order in the way that she did, couldn't she?
She could have said that in the judgment, but on one view, then it doesn't make a great deal of difference whether she makes an order or not.
Well, I think distinguished constitutional lawyers present in court would argue it does make a difference because of, I was not including myself, in case you wondered, would argue that it does make a difference in many circumstances because of separation of powers,
Everything else.
etc., etc. I mean, if she clearly says in her judgment what she just said,
yes,
didn't make the order, the Secretary of State would. You accept the Secretary of State would have the power to make the decision on new material.
yes,
She has that either way. What she can't do is make the same decision on the same material because that would be contrary to the judgment.
yes.
So why do you need the declaration, which if constitutional purists would say it infringes
Well,
separation of
when one
powers?
puts it that way, I respectfully accept we probably don't, but it doesn't mean that the judge
I know.
erred in
It's
principle.
not my job to
in
persuade
taking
you.
that
It's your
step.
job to persuade. It's not my job to persuade you, Mr. Mackenzie. I'm sorry, I don't mean to go too far. I just
No,
want to test your argument.
No, if that had if she'd simply expressed effectively what she says in the order in the judgment, then
That stopped.
there
And
would not have been a
to
great
be decided in
distinction.
accordance with the
Yeah.
judgment, you'd been delighted.
Yes, absolutely.
And you wouldn't be in any stronger position
Yeah.
than a weaker position than you are with the order as drafted.
No,
because you
we
accept
wouldn't, but
that-
it's a question of whether the judge was entitled to take that further step, and we say that she was,
Okay.
and that it doesn't make a material difference. Doesn't, in fact, as my lords have just said, really make any difference to the Secretary of State's position. She's not being precluded from doing anything by this order, which she wouldn't have been precluded from doing so if the judge had left it as a quashing order plus judgment.
I suppose it would be open to her. She could have made paragraph 4 and omitted paragraph 3. But anyway, that's.
Yes, I don't recall. I think my young friends granted appeal were against both 3 and 4,
Right.
or possibly just against 3.
The overall effect is mandatory.
Yeah. Yes, I mean we say that's not quite right. It's mandatory on the basis of the existing
current material.
but does still leave it open to her on a constitutionally proper basis to make a further decision if she has reasons for not doing so. Unless I can assist further, I'm sorry. I'm just realised we're
Just
at
ask
4
you a
o'clock and my
question,
friend hasn't had a chance to reply.
Do you want to say anything about the submissions that were made about section 31 5 capital A
We addressed that in our skeleton maybe.
All right, so you just want to rely on what you say in your skeleton.
Yes, I don't think I want to add anything. All we would say about that is it applies only in the case of courts and tribunals. It's additional to the power to make a mandatory order. It doesn't replace the power to make a mandatory order, or indeed a declaration of the sort that we've got. So it's simply not applicable in our respectful submission.
Thank you very much, Mr. Mackenzie.
My lord, I'm conscious that of course there are lots of them today, and I'll be brief.
We have a lot of it was interrupted by us. So please take whatever course you want. You must have your opportunity to say what you want and don't constrain my time.
I'm grateful, my lord. Just a few brief points. First of all, I don't in respect accept that there is a different case being run for this court than is being run below. And certainly I haven't intended to put a different case. My submissions emerged out of the written materials prepared by my learned friend who unfortunately isn't able to be here today. The normal position under the transitional arrangements is the normal position by reference to the discretionary leave policy, that is, that after 6 years you get settlement. That's the norm from which the Secretary of State is departing. The reason for that departure on the decision was because of criminality reaching a certain level. That departure from the norm under the old policy is not, though, entirely unstructured. It does reflect application of the transitional arrangements and other parts of the current policy to which I took you, and I think effectively the same materials are relied on below, I think, in the detailed grounds and the skeleton argument. I won't ask you to turn them up, but for your note, the detailed grounds, paragraphs 40 to 47, core bundle at 165 to 166, and the skeleton argument, at paragraphs 20 to 23, in the core bundle at 1110 to 1111, also referring to the legislative provisions section of the discretionary leave policy, and to the provisions that, in my submission, bring in the reference to Part 9. The structure to that departure from the norm is by reference to the criminality thresholds, which in my submission is best understood as being a reference to the thresholds in Part 9. Those have changed over time. They're now tighter than they were, and that may reflect the fact that criminal offending in this context is treated more seriously than perhaps once it was. In my submission, those submissions are entirely consistent with what has been submitted below and don't represent any different case. I'm not, though, going to repeat the submissions I've made as to their merits, which you've already got. Otherwise, three very brief points.
Right.
Just in relation to the Duke of Sussex case, there was a reference there, obiter, to reference departures from immigration policies as being perhaps illustrative of circumstances in which
Yes, that's what
more
the Master
rigorous.
Rolls said, wasn't it?
My lord, that's right. In my submission, that should be treated with a little caution. It wasn't, of course, an immigration policy that was under consideration, and immigration policies vary enormously across the field. From situations, for example, the points-based scheme, where you might have very tight policies that are tantamount to rules with very little room for exercise discretion. That's very different from a policy, like the policy issue in this case, which is concerned with discretionary leave outside of the rules, and in its own terms is setting down norms rather than rules, and that might point to a departure being permissible in broader circumstances than might be the case in other areas of immigration. The second brief point, hopefully without repeating myself too much, just in relation to how Ellis is to be looked at, I think it's important to bear in mind that in Ellis, Mr. Justice Chamberlain wasn't considering a pure historic offending case. And we have to be careful about inferring what a judge would or wouldn't have decided, how they might or might not have expressed themselves when faced with a different case. Plainly recognise that the Secretary of State enjoys a very broad discretion when it comes to the use of the word normally. The fact that the most straightforward route, in a sense, in the case before him was the reference to the new offending doesn't justify an inference as to what he would have found on the basis of a historic offending case. And then finally, just very briefly in relation to the ground 2, I don't accept the respect that delay would be justification for the court in effect taking over the function entrusted to the Secretary of State. And secondly, it's not my submission simply a matter of form. There may be reasons that are not based upon new material, on the basis of which the Secretary of State could lawfully reach the same conclusion. It wouldn't be for me to fashion those. I'm not saying that anticipating what the outcome would be. But obviously it's for the decision maker to reconsider the decision. That consideration having to be a lawful consideration with regard to the findings and decision as to the law that is made in the judgment. But it's wrong in principle my submission to foreclose the possibility of a different decision. Unless there are any particular other matters. Those are my submissions.
Thank you very much, Mr. Anderson. We're very grateful to all counsel, all advocates, for their work in this case, and for those who sit behind them. High quality representation on all sides, may I say. We're going to reserve our judgments in this case. That means that you will in due course receive drafts in the usual way for you to correct any typographical or minor factual errors, obviously not to re-argue the point. Please remember that the draft is confidential to those to whom it is distributed. On the list we've been given, any unlawful disclosures of contempt of court in accordance with the rubric at the top of the draft. In due course, when we get your comments back, the judgment will be handed down electronically with no need for any attendance. We'd be grateful if you would draw up an order that reflects our decisions. If there's any disagreement between you as to the terms of those orders, we'll deal with those in writing on the basis of brief written submissions, if you please. Thank you very much.
All right,